number 11, the people of the state of New York versus Gerald Francis. Good afternoon, counsel.
Good afternoon, Your Honors. Harold Ferguson for Appellant Gerald Francis. We'd like to request 2 minutes for rebuttal.
You may.
This is a strange situation. A client, we file a motion.
So how do you get around the plain language of the statute?
Plain language of the statute, very simple. The decision here is we filed a motion, it was denied. That decision is adverse to my client.
But that's not what the statute says, I think, going to Judge Feinman's point. It doesn't say the decision is adverse, right? What does the statute say?
It's talking about any issue of law, any matter of fact that was decided adversely to the appellant. The issue here is you're looking at a court that has engrafted a standard onto the 44020 statute that doesn't exist.
Well, let's talk about 44020 for a second. I'm not sure I see how 44020 even contemplates a motion to challenge an illegally low sentence. What that statute says is that that setting aside the illegal sentence, right, doesn't invalidate the status of the underlying conviction. And the court must resentence to the correct sentence.
That's correct, Your
All
Honor.
right. So here, the court can't do that, right? Because it would present double jeopardy problems.
No, it doesn't present a double jeopardy problem because by filing this motion, my client is waiving any double jeopardy
Do
issue.
you have any case that says you can do that? That you can waive double jeopardy? Is there any case law on that?
It's anytime the defendant tries to overturn any conviction, it is in
Waiving double
essence
jeopardy?
avoiding a double jeopardy claim, Your Honor.
Well, I thought that double jeopardy waivers were limited to instances like a mistrial. And I think there's case law on that, but I know of no other instance I'll look at it if you tell me there's one, but.
But, Your Honor, here, again, we want you to look at what is a plenary statute.
So you're saying if you went back and you won here, you've waived that double jeopardy argument, so the court now could say, okay, you get to 2 years, go in for a year? Because that's what you're doing by waiving the double jeopardy argument.
Well, what my client is attempting to do is, my client has now been released on parole.
No, I know, but let's say they don't buy your argument that because your client misrepresented his identity to the court, you're not getting your plea back, so now you're going to get 2 years. Go in for a year. You've waived double jeopardy.
But that's not what DeForno said. What the people cited in DeForno was the defendant was advised that if, in fact, he had another conviction, that therefore he wouldn't have the opportunity to get his plea back. There is no such thing.
Let's say they don't give you your plea back. You've waived double jeopardy, could you get more time now?
Absolutely.
So you could?
Absolutely.
So
and in fact, that's exactly what my client.
Wouldn't you then, if he gives you did time, you finish, you got 6 plus probation, right, on the 88? Is that right?
Yes, Your Honor.
6 plus. So then he'd go back, but it was 2 to 4 that he could have gotten. Is that correct?
That was the minimum that he would have
Right.
gotten.
All right. So let's go. He goes back and he gets 2 to 4. Isn't that subject to an immediate double jeopardy challenge?
Your Honor, he's looking. What Mr. Francis is looking here is the opportunity to take this case back to trial. When he gets his plea back, he would be looking for exoneration here. When we filed this originally,
I understand what you want to do, but you have no right to say that that's going to happen. The second thing you have no right to say is going to happen, you go back and you get a reconsideration and it's denied. Some 44020 motion, it's just simply denied again. I guess what I'm saying is I understand how you argue it's adversely effective. It's an intelligent argument. My question is your argument is predicated on outcomes that are not guaranteed and that it seems like a trial court has the right to exercise, for instance, in sentencing, an amount of discretion that will automatically create legal problems that abolish the right that you're trying to achieve.
I don't agree with that, Your Honor. Again, looking at 44020 as it is, and it was amended in 1995 and it was expanded as a scope, there is nothing in that statute that says you can't, that there is an aggrieved by the error standard. There's nothing in that statute that says I can't go back in and challenge my client's sentence as being illegally low. The legislature had the opportunity to do so. They chose not to do so. Here, when this began, the goal of my client was to try and get out from under his mandatory violent persistent
Right, I
felony
understand.
offender status. He has now been released on parole. I spoke to him again this morning to ensure myself that he understood that the possibility now is that if we were successful, and this gets, and again, all we're asking for is an appellate review by the appellate division on this issue, is that the possibility is this could lead to you being re-prosecuted on the 1987 case. You could be you could be convicted after trial, and you could go back to prison. And he says he understands that, and that's exactly how he wishes to proceed here. So
So this falls under the
The likelihood
category,
that they're
this
gonna
falls
have
under
to
the
have another
category of
from
be careful what you ask for in life?
well, Your Honor, this was a whole series of cases that I had with Mr. Gould, Mr. Benjamin, Mr. Francis all together.
He's taking his chances that in a 33-year-old prosecution, the witnesses may not be around anymore.
But again, Your Honor, this was a simple gun possession case. All you would need is the element of operability there and something of the arresting officer who would have been able to testify. So we're not talking about some complicated case that's
Well,
involved
we don't know where
here.
the arresting officer is.
No, we don't know where the arresting
33
officer
years,
is.
there's a good chance he's retired or she's retired, but
But I would like to go back to Judge Garcia's point about that he falsely gave his name. We don't know that.
He forgot his name.
No, we don't know under what circumstance that he was prosecuted under the name of Gerald Francis. There's nothing in this record that
No,
indicates
but he
that.
knows when he stands up in front of the court and they're saying you, whoever you are, don't have a prior conviction. He knows that's not true. He knows he has a prior conviction.
Again, Your Honor, there was nothing in the plea colloquy that talked about a prior conviction whatsoever. That's the forno, which the people are relying upon. There was
And then
nothing
the
that
next time, and it seems to me that every time this happens, and it happens 2 or 3 times, where he has used a different name to avoid being sentenced as a predicate for whatever past he does have, he gets out of it until the last time when they, maybe because of technology, they connect all these aliases he's in one way or another been using. So at the end, in 97, he gets the 23 to life sentence. And now, it seems, and very openly if you admit this strategy, is the mirror of that strategy to try to take out these convictions based on the fact that they didn't know his real identity and do exactly what he did before, which is avoid the predicate status, in this case, by manipulating the timing of the convictions and sentences.
But again, it's not a matter
What
of
kind of
games.
message is that? I mean,
No,
as an
but-
adverse result for your client.
But, Your Honor, here, in my answer, Your Honor,
Yes, of
what we're talking about here is assumptions that are being made, and that in the 5 months that this case continued to exist, from the time of arraignment till eventually plea and sentence, that at no point, it was simple. All you had to do was run his fingerprints through SAFES and it would have come out. And
97, he had an offer that was much better than this that was then pulled off the table, right?
that's correct, Your Honor.
And why was it withdrawn?
It was withdrawn because they realized what his correct status was
Which
at
he
that time.
hadn't revealed until that point.
And again, you're assuming that my client is somehow versed in the law prior to 1997, Your Honor.
Based on 3 prior convictions, I'm
Based on
assuming
his
that.
prior convictions. But any type of research that this individual did was post his 1997 conviction. That's when he got directly involved into doing legal research and the like. So say that this is a level of gamesmanship. And I do want to point out that what the people have attempted to do in other cases, and we had People versus Perry, which was mooted out before this court, the people's goal is to have 470-15 declared unconstitutional as stripping the appellate courts of jurisdiction, running afoul of the New York State Constitution. So for the people to come back here now and say, oh, we're going to use this and say, oh yes, 470-15 works when it goes against the defendant, but we're going to try and overturn that in a subsequent case. talking about gamesmanship, that's gamesmanship too, Your Honor. It's like, here, there's no doubt his sentence was illegal. There was nothing in 44020 that prevented him from doing this, and that to allow a trial court judge to change
The question is whether it's entitled to have that decision reviewed.
Right. But what you would be doing was allowing here a trial court judge by judicial fiat to amend a state statute. That's the province of the legislature. That's not the province of a trial court judge. Thank you, Your Honor.
Counsel?
Thank you, Your Honors, and may it please the Court, Samuel Goldfein on behalf of the people. Below, at the 440 Court, defendant complained that his sentence was illegally lenient. That motion was denied, and on appeal, the appellate division recognized that defendant was obviously not adversely affected by that sentencing error. He manifestly benefited from it. He had created it, and as a result, that 470-15 barred its consideration of the merits of the case. Now, there's been a lot of discussion about 440-20, but respectfully, I think that's irrelevant to this case. Whether or not the underlying decision was right or wrong, the question on appeal is whether or not 470-15, which governs the scope of the appellate division's jurisdiction, applies here, and plainly, under the plain language of the statute, it does. Defendant benefited from the sentencing error, and accordingly, he was not adversely affected by it. The notion that 440-20, that the denial itself could be the error, contravenes the plain language of the statute. I think Judge Garcia pointed out that it was the error or defect in the criminal court proceeding underlying that order, not the order itself. And defendant's reading of the statute renders that adverse effect language largely pointless. Anything could be made adverse, as in this case, by raising it unsuccessfully below. Also turning to the idea that defendant didn't give false names for some kind of purpose.
What's the only basis the appellate division, or what's the basis the appellate division gave for saying it had no jurisdiction?
The appellate division's basis was that defendant was not adversely affected by the sentencing error that he identified.
Okay, so, yes, but why is that correct if his point is he's got a motion that's denied and that they have jurisdiction to determine that, and then they can reach the merits? That point is on the merits.
Well, I think 470-15 is going to require some examination of the underlying facts because the statute is commanding the appellate court to go beyond the order and to look at the impact on the defendant, whether or not there was an adverse effect from the specific error or defect in the sentence.
Well, unless I misunderstood him, and I'm sure he'll correct me when he gets up on rebuttal, I thought the argument was the denial of the motion meant that the court is not exercising the jurisdiction that the CPL provides to determine whether or not the denial of the motion is correct.
I'm sorry, Your Honor.
And there he is aggrieved because of that. Ultimately, yes, sure, the AD might very well hold against him on the merits. But
I think the legislature has just expressed a clear intent that the appellate court shouldn't be wasting resources on a case where the defendant cannot point to an adverse effect that he suffered here. And plainly, the sentencing defect did not harm defendant in any way. There was no adverse effect there. He benefited from it to such a degree that he continued to lie to the authorities about his identity and obtained a similar sentencing benefit in a subsequent case.
I thought again that his argument, and again, he'll correct me if I'm wrong, the argument he's making is the adverse effect that he doesn't have appellate review of what he's arguing is an incorrect determination about the sentencing.
I believe that contravenes the plain language of the statute. It's the denial of the order itself is not enough. It's what's the impact on the defense. And here, there's no impact. I mean, even if you're to assume that the error could be this long chain of litigation that's going to result in him unsettling his richly deserved predicate status, that he doesn't say there's any reason he doesn't deserve that. He committed all those crimes. That's beyond the scope of the statute. It's not the error or defect in any criminal.
You know, I think when I think about it, when I struggle with this case, as we all have, it breaks down into two parts. What's the meaning of adversely affected, and how broad of a meaning should we give that? Right. And sentence by sentence, I think you're absolutely right. He's not adversely affected, but in the context of recidivist statutes, it becomes more complicated and more difficult to determine where you draw the line for whether somebody's adversely affected or not. And that's why I was asking the questions about double jeopardy, because it seems to me that if we found that there was double jeopardy here, that it wouldn't be necessary for us to engage in that analysis, would it?
Right, Your Honor. Well, I think the statute itself does narrow the scope to a certain degree.
No, but stay with my question. If we found that double jeopardy applied here, would we need to engage in the adversely affected analysis that both counsel have argued for us?
No, Your Honor, because at that point, there's no adverse effect. The defendant would be left in the situation he's in now. He most likely couldn't be resentenced because of double jeopardy, and the status quo would remain. There's no adverse effect.
Counsel, to get to that double jeopardy argument, though, we would first at least have to assume that there could be an adverse effect, it's possible, in a contingent proceeding, essentially, right? That you could go back after you get after you get your unlawfully lenient sentence overturned, you could go back and use that to undo your plea, and then you could take that undoing of your plea and go and undo your sentence on the 97 conviction. But if we adhere to a rule that says you look at this proceeding and what was being challenged here and the result, we never get to the double jeopardy issue, do we?
Correct, Your Honor, and I think that narrowing of the scope is in the plain language of the statute. It's not an adverse effect that may have affected the defendant in any criminal court proceeding. It's the criminal court proceeding. And I think that narrowing is for a specific purpose because it's hard to imagine another circumstance where this type of claim would arise. The legislature is trying to tamp down on these types of appeals where the heart of them is really gamesmanship. Even the correction that defendant is seeking is not to have a correct sentence imposed. He now wants his plea back. And at 30 years after the fact, it's likely impossible that the police officers are alive or that they remember what happened, that the paperwork is still available to prosecute this conviction. In reality, if defendant is entitled to withdraw his plea, he's going to have an acquittal here. If there are no further questions, I rest on my brief and ask that you affirm.
Thank you,
Your Honor.
Counsel.
Counsel, is that your argument for harm in this proceeding, that it's because the appellate division refused to review the underlying issue?
Absolutely, Your Honor.
But then wouldn't any time they apply 470-15, wouldn't you have harm? Like any time you apply that statute, you're not getting reviewed for whatever reason, so you always are harmed. So it's kind of a catch-22, right? So anytime you apply 470-15, I'm harmed, so there's an adverse effect, even though there's not an adverse effect leading to the application.
And this time, it's whenever there is a motion filed that is denied, that a defendant has filed, that denial is adverse to the defendant.
I understand that argument.
Right.
I understand that argument. But you're not arguing because they applied 470-15 and didn't review that, that's your harm. Your harm is the denial of your original motion.
That's correct, Your Honor. And to go back, we have to take a look at 44020 in the context of how it was amended. It was amended in 1995 in direct response to the reinstitution of capital punishment in the state of New York. And therefore, they expanded the scope of 44020 to help defendants who were facing the possibility of death, so that you have a statute.
Not to help them set aside an illegally low
That's
sentence.
correct, Your Honor, because that would be used, because all of those factors could have been used as aggravating factors.
But also 44020,
That's right, Your Honor.
right? Wasn't designed to allow defendants to set aside illegally low sentences.
It is written as a plenary statute. There is no exception to it. When they looked at it in 1995 and they decided to amend it, the legislature had the province, if they wanted to say it only applies to illegally high sentences. But here, there is no exception whatsoever in 44020.
So if the court disagrees with this argument about whether or not merely the denial of the motion in and of itself is enough to get you the agreement, do you lose? Do we have to affirm?
I hope not.
No, the question of law, as a question of law, or do you have some other basis?
I think we have to look at the overall policy considerations here. And part of the policy considerations here is what in effect has occurred in this particular case is a trial court judge looks at a plenary statute and added an exception that does not exist in the statutory language, and the appellate division is avoiding looking at amendment by judicial fiat. That can't be allowed by this court. All we're asking for is a review by the appellate division of the merits.
Thank you,
Your
Counsel.
Honors.